Welcome to the September 21st special zoning board hearing for the pre-development issue. And I'd like to start by saying the Pledge of Allegiance. Please rise. Pledge of Allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, Mr. Sander, take it away.
Thank you, Mr. Chairman. This is the 10th hearing on the application of PREET for a special exception for an apartment use at the Plymouth Meeting Mall. When we left off last time, which was August 3rd, we asked the parties for submission of proposed findings of fact, proposed conclusions of law, and memoranda of law. Both parties provided those documents to us, and they have been distributed to the zoning hearing board members, and the zoning hearing board members have reviewed them. We continued the proceeding until tonight to take any remaining public comment that might be forthcoming, and to hear oral argument from the attorneys for the parties, and then the possibility of deliberation and the possibility of a motion this evening. So the first order of business this evening is to call for any public comment.
David, I've got to run out to my car. I've got materials that I left in my car.
Okay, why don't we just go off the record and take a 5-minute break? Okay, no problem.
My house is pretty small. Is it? It's only 1,500 square feet. 1,300. Yeah. Oh, inside you have some 1,400? Wow.
I think they're knocking sections down. I'm not sure if they're knocking this whole thing down, but they're literally getting rid of the stage in here, so we don't look all pompous up here. So, but yeah, I'm not sure when they're starting this room, but to the entire township building. So they just told me I have to pack up my things by the end of this week. So I'm going to the community center. That's where my office is going. No, or eventually, but not right away. So no one even knows if it's for real, if we're actually leaving this weekend. So we'll find out Monday morning. There's a wrecking ball going through my office.
When's expect to be done, Dave?
What's that? Right. Exactly. Yeah, I know. Mm-hmm. Was that the?
No, it says 71 on the building.
Yeah.
There's a stone on the building, because we were looking at that last night. How long until they're done?
I don't know anything. No one tells me a thing. So
But this auditorium's not going away, is it?
they're at least modifying, from my understanding. Like they're getting rid of the stage, and everything's going to be on one level.
Hey, there's no ordinance because
Yeah, it was nice.
David told me that,
It's a big yard, it goes up at the top.
This is
Yeah. I'm
That
sorry.
only
Yeah,
went in
I'm
a
outside
couple
all the
years.
time.
You know what?
What's the date on this?
I come by.
But yeah, it was probably later in 18 it went in. It's in there. I don't even know if it's in the line.
Bring my shoes if I could, yeah. I would come in and say, I was
big deal.
No, it was put in within the last couple of years.
No big deal.
Yeah, it's in there.
Oh, that's nice.
You shouldn't trust me, but it is.
You have like landscapers? Come on. You do it?
No, literally, I think 18 or 19 it was. I tried to find it on my phone if you want.
It's good. Oh, we're ready. Hi, Mark. Are you ready? Good. Okay, let's go back on the record. At this time, I would ask for any public comment on the application. Does anybody wish to make public comment? Come on down, please. I'm going to ask you to state your name, spell your last name, and, yeah.
Marlene, M-A-R-L-E-N-E, Peltz, P-E-L-T-Z, Chaikin, C-H-A-I-K-I-N. Yes, I do. Thank you. Hi, I want to state that I am opposed to the apartments being built. I live at Plymouth Hill Condominiums. I've lived there for about 26 years. And over the years, I've seen a lot of traffic through and through. The traffic is a nightmare during rush hour now, especially since school is back and people are back to work. I drive that road 7 days a week, but Monday through Friday during rush hours, morning and evening, well, afternoon. When you add 503 units to the mix, it will be even more challenging. I don't think the traffic studies were accurate, to be honest with you. There have been times when traffic has actually been gridlocked during storms, rain and snowstorms, where we could not even get out of the complex. I can't imagine that it's going to get any better with adding 503 units and all the cars that go along with it. There is a 400-unit luxury apartment building called Avenue, exactly 2 miles from the entrance of the mall. It's been open for about 1.5 years, and it's still not fully rented. There's another new apartment building down Germantown Pike called Residences at Brentwood in East Norriton by the Hyatt. That is not even fully rented. I can't imagine how they're going to be able to rent a 503-unit complex. The ring road in the mall, as I mentioned last meeting, I was caught a little off guard when you called for comments. The ring road in the mall is absolutely a disaster. It's a disgrace. It needs repaving and redesigning. I'd like to know how they're going to maintain the road better with increased traffic, because they can't even maintain it now. They stated that they were going to modify the Whole Foods entrance coming in off of Germantown Pike to make the traffic on Germantown Pike flow easier, but that's not actually where the problem is. The traffic flows in fine from there. It's the way the cars come in once they merge to come down toward Whole Foods entrance that has been the problem, and they have not shown any good solution to that. The entire ring road would need to be completely redesigned. They propose to possibly close off one of the entrance or exit access areas to the main ring road near the Shake Shack. That would only create more of a backup on the ring road coming down from the Whole Foods and the AMC Market and even from Miller's Ale House. It's already backed up at times during high traffic at the mall, and especially when the movie lets out, you can wait almost 5 minutes just to get out of the mall. They proposed a right turn only when you come in at Lawnfall. That would mean that people, at least until they get used to the traffic patterns, would have to go all the way around the mall in order to get to the restaurants. That will create more traffic around the entire mall area. They didn't seem too agreeable to adding a different entrance or requiring the drivers at the apartment to go through Hickory Road, that could possibly be another area where they could do it, but I can't see where that's going to actually improve the traffic at all. Because of those reasons, I'm totally opposed to this being done. Thank you.
Thank you.
Thank you. Any additional public comment? Come on down.
Hi, good evening. My name is Linda Trembath, Trem, as in Mary, B as in boy, ATH. And,
Address?
thank you.
Oh, yeah, no, you can swear and then we'll get her.
You solemnly swear or affirm the testimony that you give is the most truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do. I live at 9 Camelot Drive. I've been a resident in Plymouth at 9 Camelot for about 25 years. I live at the neighborhood directly across from the mall, so I am deeply concerned about this proposed apartment building going in. I'm deeply concerned, of course, pretty much exactly what Marlene said, about the traffic in the area if this plan was to go through. I was able to sit in on some of the previous Zooms that I had listened in on the traffic studies and that were shared, and they were trying to say that it would not make much difference with the impact on Germantown Pike and in the area, trying to say that not everybody leaves at the same time. However, I beg to differ that right now it's already a concern with our growing area. And also, when they were discussing the traffic studies, they were talking a lot about doing these prior to the, or during the pandemic, and also prior to a lot of businesses even being open. The Shake Shack was not open at that time. Other businesses at the mall have the salon, I'm not sure of the exact name, with a different stylist and things that was not completely open. There was a lot of different factors that did not go into their study. This also was not discussed that the development on Johnson and Plymouth Road was not even built at the time, and they're still currently building, and they keep adding more and more houses. So if you figure all the cars per house there as well. We can all do the math that clearly adding 503 units with 2 cars per unit at least, I'm a 3-car, 4-car household, would be over 1,000 cars that we're talking about. Our neighborhood right now, being right across from the mall, is often used for a cut-through right up Lawnfall. I walk every night. I used to go to the Edge. I still am a member, but until COVID, I walk the neighborhood constantly, and I see people blow through stop signs and race through our neighborhood just to cut and avoid Germantown Pike traffic. So I'm deeply concerned. There's a lot of children. I have teenage kids that drive. It's a concern. Adding all these units are only going to make it worse. Also, my concern, which a lot of people say, oh, but the mall is empty and we need to do something with the mall. The mall is empty, as is many malls in the area. Exton Mall, down where I work, is empty. Montgomeryville Mall is, every time I go, there's businesses out. There's also strip malls that also have open, vacant spots that are available. So adding these units would not do anything with the mall. The mall would still be a concern. Instead, I think you're going to find people are going to be less likely to go to that area because they're not going to have any parking. Currently, it's a problem. When I was a member at Edge, I couldn't find a spot over by Whole Foods and Edge, and then over by Legoland just to run in to get pizza. It's a difficult area to find parking, and then on the other side by the restaurants, again, that's without any additional apartments. Perhaps think outside the box and use the area for green space, or be like King of Prussia and add more restaurants and things, but without the 503 apartments. I'm really concerned about what this would do for our small community. Thank you very much.
Thank you.
Thank you, Ms. Trimbuth. Is there any other public comment?
Helene Estes, 111 Delancey Place. 111. Oh, Estes. Estes. Helene, Helen with an E.
111.
Delancey.
You solemnly swear or affirm the testimony that you give is the most truthful, whole truth, and nothing but the truth,
Absolutely.
Hello. I've been living here for a total of 3 weeks. A total of 3 weeks. So very, very new to the neighborhood, but I also spent 35 years in West Norton Township and very much aware of traffic studies and impact to communities as it related to the Westover Golf Course, if anyone's familiar with that. What was exciting about that is that the township recognized the need, the township members of the board recognized the need of the community and took the community's needs above the needs of development and really supported the community. So I just use that as a point of reference. However, life's about facts. So listening today, I have to ask you, where I live, what's the impact to the traffic on Plymouth Road? Anyone knowing what happens when you come out of the mall, everything gets clustered coming out of the mall, trying to make a left-hand turn onto Plymouth Road is quite an adventure. And then if you look at all the other things in terms of the traffic impact, look at the turnpike. From the turnpike to 202, the amount of traffic that happens. So that goes in both directions. As you know, Amazon is going into the East Norton Walmart area. That'll create more traffic, truck traffic. I don't know if anyone's gone on the 476 North at any time during the rush hour and looked at that from their own personal experience. But life isn't about personal experience. Life is about facts. So the question is, will the township request that the developer start with a brand new traffic study and use a fact-based information and use a company that the township would recommend instead of what the developer is taking on as a traffic study? So that's a question I have for the township. We don't want to be King of Prussia. We want to be Plymouth Meeting. King of Prussia is a disaster. Anyone who goes into that footprint knows that it's just a very dense environment and a lot of traffic. And I think one of the reasons I moved to Plymouth Meeting is that the township really understood growth, has a lot of green space, and I think that's what your responsibility is to community. We have enough areas that you cannot control, which is the space from Plymouth Meeting Metroplex all the way to 202. It's a public highway. That's not something that is part of Plymouth Township that they own, correct? Right? That's Germantown Pike. That's part of Pennsylvania State the Department of Transportation. So maybe they need to be involved with the traffic study, because just the traffic lights and setting those traffic lights from the other side of the Metroplex, where Plymouth Meeting Friends School is, all the way to 202, all those traffic lights would have to be adjusted to take on 500 plus new cars. So that's one of my questions is, how can you encourage the developer to say, take a pause, let's reset, let's start with a brand new traffic study, because that's the critical piece here that allows you to support our community, because that would be fact-based. So that's what I have to say. Thank you.
Thank you.
Thank you, Ms. Estes. Is there any additional public comment? Any additional public comment? Okay. If there is no additional public, oh, there is. That's okay. That's quite all right.
My name's Debbie Livesey, and I live on Skip Road.
Spell your last name, please.
Oh, Livezey. V as in victory, Ezey.
Well, you have to be sworn in.
I do, including my name.
What's your address?
15 Skip Road.
Okay, gotcha.
Unfortunately, I didn't hear her whole presentation or what her comments were, but I concur with just about everything I did hear. Traffic is my main issue. I mean, I have to go through, come down Germantown Pike and take 476 to go to my job every day and come home, and it's a nightmare, especially at Christmas. The mall is, just the traffic around the mall. People go to the restaurants, that's fine. The mall needs some help. Everything's closed up inside. It's pretty sad. I don't think that 500 or even 400 apartments is the right answer. I think there could be some other alternatives. I don't know what they are, but there's a lot of smart people that can come up with some good ideas. But traffic is the biggest concern, and you sit and you sit and you sit. Not to mention sinkholes. You all know that the one on Butler Pike was under construction for a long, long time. Now there's Chemical Road that's been closed down for who knows how long. And now all that traffic is being diverted, even closer here to the mall. Then there's the septic system. You're going to have more people tapping into the sewer system that may already be strained. I don't know how old the system is, but that's another concern with additional people using the septic system that's already in this development. I don't know. I just wanted to give you my 2 cents, and I really am against it. And so I hope and I pray that you look at another traffic study, as the other woman had mentioned. I don't know if there was one done. If there was, is it public knowledge? I understand from my work that the developer is the one that pays for that study to be done. Part of me thinks that could be conflict of interest, really. If there's a traffic officer or a engineer on staff, that they should be the ones looking at that objectively and to support and look out for the township and how does it align with the township's code, et cetera. But the traffic study, I think, should be refreshed, especially since the 2 Amazon facilities are in the area. So I think a fresh study would be good, and another, I agree with her that maybe the township could recommend a different company to do a second one if there was one done already. So that's my thoughts. Thank you.
Thank you.
Thank you, Ms. Livesey. Any other public comment? Sir?
I'm Debbie's husband, Kurt Livesey, C-U-R-T, spelled the same way, L-I-V-E-Z-E-Y. Yes. Born and raised here in Plymouth, and of course a lot has changed. Back in, I'm 57. I know a lot is going on. I mean, I with all the building and stuff like that off of Plymouth Road across from Plymouth Elementary, we got 79 homes there. You got Amazon going up on East Darton. You got Amazon going, I believe, off of Ridge Pike there on right across from the old Stroman. I don't know what's being built there. There's so much development. I think we should really take the time and research, a traffic flow, sewer, vacant land study. I mean, there's so much that if it's going to be 500 or 200, I don't think we encompass that on Germantown Pike in our thoroughfares in this area. You got the Plymouth Junior High, you got Plymouth White Marsh right up the road. You got school buses. I just think you have so much volume of traffic that's engaging on two lines of traffic. You got Ridge Pike and Germantown Pike. Of course, like my wife had mentioned about the sinkholes. I think where's all this water go to? All this storm water go to? I mean, we have all this land development, and we're having problems finding areas for this water to go to. And whether it's being addressed or it's not being addressed properly, maybe it's because of limestone, because the ground is so porous. Water gets in around the pipes and stuff like that and causes problems. I think we really need to sit down and, before we make any kind of decision, and do some research with the planning commission, with the stormwater people, with the vacant land study, and traffic study, sewer. I'm totally against it. I just don't feel at this time, maybe we can find other means, or maybe build something else there that would be beneficial for everybody. It just seems like, I was just recently in my neighborhood, my old neighborhood off of Woodbrook Lane where I grew up, and Woodbrook Lane and Pleasant Road and Hollow Road, they just built a couple houses there. And it's like every little parcel, I gotta build. Where's it stop? It's just hurtful to just see all this building, and it just seems that we're just taking land away. And we have one of the oldest existing farms that are, thank gosh, is still in use, right next to Harry Hill, Weather Hill Park right there. And, it just seems like, well, the people don't want to farm it anymore, but we just keep on seeing what we take. And whether it's a need because we need money coming in, but you look at all the vacant, the lots around here, as far as the offices and stuff like that. It's terrible. You go through that little cutoff through Plymouth Road to go the back way to Lowe's, and half those things are empty. And it's hurtful. And then the Plymouth Meeting Mall, that's pretty much dead. Granted, probably because of rent and whatnot, it's very expensive, I'm sure. But where does it stop? Do we have to consistently build? And for what? I just feel as though the kids growing up today are going to be stifled with, it's going to take them an hour to get to school. I used to walk to school, and it wasn't much traffic. I know this is moons ago, and times do change. But it just seems like we just need to address the bigger issues as far as what we can do better with that parcel of land. Because it was the Plymouth Meeting Mall, and then there was that high-rise right next to it there that I don't even know what's there anymore. I just feel as though we need to address some issues. Maybe put in a monorail system. I don't know. But I know years ago when I was going to school out in Pittsburgh, they built a subway. It was only a mile long. And I know that's far-fetched, but I just feel for this township. I love where I live. I'm getting emotional a little bit, but I just think we should just take the time and do some really research and figure out what we can do best for our township going forward. Thank you for your time.
Thank you.
Thank you, Mr. Livesey. Is there any other public comment on the application? Any other public comment? Okay, seeing none. Mr. Kaplan, would you be so kind as to present your oral argument to the board? Mr. Kaplan, let me say to all council. Obviously, the zoning hearing board has your proposed findings, conclusions, and memoranda. They've read them. They are familiar. I would ask that council please argue, keeping in mind that all of the issues have been briefed and the zoning hearing board has read them. And I'd like you to try to hit your most important arguments. Hit them, and let's wrap it up. So thank you.
Excuse me. I put together binder for everybody of items that I'd like to call to attention during my oral argument.
Thanks, Mr. Kaplan. Thank you. Appreciate it.
Good evening. For the record, I'm Mark Kaplan. I represent Pennsylvania Real Estate Investment Trust, the owner of the Plymouth Meeting Mall. Preet has filed an application for special exception to construct an apartment building on the mall property where the old IKEA building is located. We believe that Preet is entitled to the special exception because an apartment building is a use of the, quote, and there are 3 words, same general character as a motor court or an elderly housing assisted living facility. You've heard 9 nights of testimony. You've received the proposed findings of fact, the proposed conclusions of law, and our written legal argument from Preet and the township. I think it's fair to say that Preet and the township have completely different perceptions of both the facts and the law involved in Preet's application. It is my intention tonight to differentiate Preet's legal and factual positions from those of the township, and to demonstrate to you why Preet's factual and legal positions are accurate and correct, why the township's view of the facts are not supported by the record, and why the township's legal position is not supported by numerous Commonwealth Court decisions that have dealt with the key question in this application. And that key question is, when does a proposed use, such as the proposed apartment use, qualify for approval as a special exception because it is of the same, and I use the same 3 words again, same general character as other uses permitted by the zoning ordinance. To help you follow parts of my presentation, or to review our materials when you deliberate about this case, I have assembled the cases that we rely on, portions of the record that we rely on, and portions of the record that contradict the township's factual positions, and have given each of you a loose leaf binder of those materials. Now, as set forth in our brief, Preet has the burden to prove that its proposed apartment use is a use of, again, the same 3 words, the same general character as other uses permitted in the township shopping district or shopping center district, and that is where I will start my presentation. In this aspect of our case, the legal part of it, the township and Preet agree on one fundamental concept. We have both cited you to the Commonwealth Court's decision in Cook versus the Zoning Hearing Board of Ridley Township for the proposition that, quote, whether a proposed use falls within a given category specified in a zoning ordinance is a question of law. So we both agree on that concept. Okay, but what does this proposition mean to you as you deliberate over this case? Here is what I think it means. You have heard each side present its witnesses and documents to convince you that their recitation of the facts is correct. Now you have to assess both sides' presentations and make your findings of fact. But that is only the first step. After you make your findings of fact, you must apply the law to those facts. In my opinion, in this case, there is only one way to properly apply the law to the facts, and that is to conclude that the proposed apartment use is at the very least of the same general character as the elderly housing assisted living facility permitted in the shopping center district. Furthermore, we believe that the proposed use is also of a use of the same general character as a motel or motor court. Now, in my book are all of the cases which Preet relies on as authority for its legal position that the proposed apartments is a use of the same general character as a motel, motor court, or elderly housing assisted living facility, uses that are permitted by the zoning ordinance. I am going to highlight for you the portions of each case that we believe will compel you to the legal conclusion that the proposed apartments is a use of the same general character as the permitted uses that I've talked about. Again, the first case is Cook versus the Zoning Hearing Board of Ridley. Cook is cited by both sides for the proposition that whether a proposed use falls within a given category specified in the zoning ordinance is a question of law. As I have just stated, that means that after you determine the proper facts, you have to apply the law. And I'm going to tell you about the facts and come to... you have to... I apologize. As I just stated, that means that after you determine the proper facts, you have to apply the law that I am going to tell you about to those facts and come to a conclusion as to whether the proposed apartment use is a use of the same general character as the other uses permitted in the shopping center district. The second case is the Commonwealth Court's 2014 extensive opinion in Mark West Liberty, Midstream, and Resources LLC versus the Cecil Township Zoning Hearing Board. Mark West involved the issue of whether a proposed natural gas compressor station was, quote, of the same general character as the other uses permitted in the Cecil Township Light Industrial District. The Township Zoning Hearing Board said that it did not. The county court said that it did not. But the Commonwealth Court said that the gas compression station was, quote, of the same general character as the other uses permitted in the light industrial district. Now, what's most important about Mark West is that in reaching that conclusion, and it's a long opinion, the Commonwealth Court recited a number of rules for the application of the law to the facts in cases such as ours where a use of the same general character is permitted by special exception. And I've highlighted some of these concepts in the copies I think I gave you. Now, first of all, on page 5 of the Mark West opinion, the court states that, quote, ordinances are to be construed expansively, affording the landowner the broadest possible use and enjoyment of his land. Now, I'm sure Mr. Sander will tell you that this is a fundamental concept of constitutional law in Pennsylvania and implies in all situations. That is, because zoning limits a property owner's natural right to use his property in any way that does not hurt his neighbor, zoning ordinances which limit that right are to be interpreted expansively in favor of allowing the broadest right to use the property. The second concept in Mark West is on page 6, where the court reminds us that a zoning hearing board is not a legislative body and cannot amend the terms of an ordinance. The court goes on to say that because it is not a legislative body, zoning hearing boards are required to apply the terms of the ordinance as written, not as they would have liked them to have been written. This limitation is very important in this case because the township zoning ordinance is very broad, in that it permits, again, any use of the same general character as any other permitted use. It does not merely allow uses of the same character, and that is that the insertion of the word general makes the permission granted by this provision very expansive. Tied together with the first concept that zoning ordinances are to be interpreted to allow the property owner the broadest use of his property, in applying the law to the facts in this case, compels you to err on the side of the property owner and makes this provision a very accommodating provision to the proposed apartment use. Now, the third concept in Mark West that I'd like you to look at is on page 8. The court emphatically applies these two concepts to Mark West's proposed compressor use as follows. This is a quote or close to it. Further, the board's legal standard in conclusion number 12 that the proposed use must be of the same character is simply wrong. Section 911 of the UDO is clear that the proposed use is to be of the same general character. We must refer to the plain meaning of the term general. This is a quote from that case. Merriam-Webster Collegiate Dictionary defines general as concerned with the universal rather than the particular aspects of the proposed use. Thus, the UDO does not require the proposed facility to have the, quote, same character, but rather a similarity. I repeat that, but rather a similarity to other uses proposed or permitted by the zoning ordinance. Now, I'd like to apply these two rules, that the landowner is entitled to the broadest use of his property, and that by including the word general in the phrase same general character, the ordinance dictates that your analysis must concentrate on a broader more universal comparison of the uses, rather than comparing various specific characteristics of the apartments and the elderly housing assisted living facility. From a general point of view, both uses are housed, the elderly housing facility and the apartments are housed in multi-story buildings that are divided into multiple apartments and common areas. Both buildings serve as permanent residence for the tenant, and both provide adjacent parking. Those are the general comparisons. The township would have you divert from the general analysis and have you concentrate on specific differences. The elderly housing provides meals and the proposed apartments do not. The permitted number of units in the elderly housing facility is limited to 150, and the proposed apartments are 503. Well, if the drafters of the ordinance wanted the special exception uses to be of the same character as the permitted uses, it should not have used the phrase same general character. Furthermore, the drafters were not compelled to include a special exception use for other uses of the same general character. They could have simply limited the permitted uses to a list of clearly defined uses, but they did not. They included uses, again, of the same general character as other permitted uses. And PREIT is entitled to the broadest use of its property as long as the use does not harm its neighbors. Moving on to the third case. It's Van Sciver versus the Zoning Hearing Board of Philadelphia, a 1959 decision of the Pennsylvania Supreme Court that expands on this concept of generality. On page 4, the court says, quote, "A laundromat is more in harmony with the general pattern of zoning in this area than some of the other uses permitted by right. Thus, it is clear that the board should have granted a certificate and not a variance on which it attached offensive conditions." That's what the court said. The statement that the proposed use should be in harmony with the, quote, general pattern of zoning is particularly applicable to PREIT's case. As Mr. Comita told us, and as even a brief review of the township's 2040 comp plan reveals, the township's comp plan repeatedly says that the zoning should permit the revitalization of the Plymouth Meeting Mall. More particularly, the 2040 comp plan says that both apartments and elderly housing assisted living facilities should be developed on the Plymouth Meeting Mall. There can be no question, at least no question in my mind, that the proposed apartments are in harmony with the general pattern of zoning in the area. As Seth Shapiro testified, the Plymouth Meeting Mall is at the intersection of Main and Main, at the intersection of the Pennsylvania Turnpike and the Blue Route and Germantown Pike, where there are multi-story hotels, multi-story office buildings and condominiums and apartment buildings which are located close by. I guess that it is fair to say that the best example of the high-density zoning around the intersection of the Turnpike and the Blue Route is the 15 or so story office building that is located smack dab in the middle of the mall. Clearly, The proposed apartments are in harmony with the general plan for the area. I want to switch gears a little. And in the next cases I'm going to present to you and are in my book are examples of the Commonwealth Court and the Supreme Court's history of applying the foregoing principles to determinations of whether a proposed use is of the same general character as other uses. In Valley Forge Plaza versus Upper Merion Township Zoning Hearing Board, a 1991 Commonwealth Court decision, the court held that an off-track betting use proposed for the Valley Forge Plaza Hotel was a use of the same general character as an assembly hall. Yes, I said the question was, is an off-track betting facility of the same general character as an assembly hall? Upper Merion's position was that because pari-mutuel betting windows and closed-circuit television monitors were not then uses typically found in an assembly hall, the OTB was not of the same general character as an assembly hall. The Montgomery County Court of Common Pleas and the Commonwealth Court dismissed the township's position and held that because an assembly hall is a place used for public entertainment and an off-track betting facility is another source of entertainment, the proposed OTB would be of the same general character as an assembly hall. The same should be said of Preet's application, because both elderly housing assisted living facilities and the proposed apartments provide long-term housing in multi-story buildings. The proposed building is of the same general character as the permitted elderly housing assisted living facilities. There are more examples. In Novello versus the Zoning Hearing Board of Adjustment, a 1956 Supreme Court decision, and in Sunoco Oil versus the Zoning Hearing Board of Adjustment, another 1979 Supreme Court decision, the Supreme Court determined that the washing of cars in a standalone building is of the same general character as the operation of a public or commercial garage or repair shop, gas station, and oil service station. Obviously, the specialized car wash building and the commercial garage buildings are significantly different from each other, and the storing of automobiles in a commercial garage is a different use than washing cars. But the Supreme Court twice held that the two uses were, again, the three magic words, of the same general character. These cases, in my opinion, are further support for you to conclude that the proposed apartment building is of the same general character as the elderly housing, assisted living facilities, or the motel or motor court. There's another case that demonstrates the generality of the application of those three words. It's a Bucks County 1972 case called Dick Hopkins, Inc., where a retail establishment for the sale and leasing of camp trailers, mobile home campers, recreation facilities, and supplies was determined to be of the same general character as a public garage, motor vehicle or farm machinery sales agency, motor vehicle service station, or parking lot. Now, obviously, in all of these examples I have given, we could pick each of the uses apart and say that they're not all the same, that there are different pieces, that they're different with this and they're different with that. But the Supreme Court, and the Commonwealth Court, and the Bucks County Court have held to the expansive use of those three words. Now, finally, the last case is a very recent Commonwealth Court 2019 decision in Zippy's Car Wash versus the Zoning Hearing Board of Ridley Township. The court held, as the other decisions I have talked about, that where an ordinance requires that a proposed use be of the same general character, the ordinance does not require the proposed use to have the same character, but rather a similarity to other uses permitted by right in the zoning ordinance. But I call particular attention, or your particular attention, to the Zippy's case. It's important. It's important to what the township, I believe, has been trying to do in this case. In Zippy, the court specifically stated that your focus should be on the similarity of the proposed use to permitted uses, not to the similarity of the proposed use to uses which are not permitted. What do I mean by that? Well, please recall that in the township's case, evidence was elicited to demonstrate that the proposed apartment is similar to a fraternity house, and it's similar to a boarding house, two uses which are not permitted in the SC district. Apparently, the township was going to argue that because the proposed apartment is similar to two non-permitted uses, it could not be of the same general character as the two permitted uses that I've referred to. So that's my recitation of the law. And remember, I said that it's Preet's burden to demonstrate the first thing, and that's the use, that the use is right. And I've spent a lot of time going through that and showing these cases to you. But then our burden continues. And I have to demonstrate to you that the evidence that we presented satisfies the remaining criteria or the remaining items that are our burden to prove. Specifically, Preet has the burden to prove that its plan complies with the objective area, bulk, and parking criteria of the zoning ordinance. To satisfy that burden, Preet presented the project's civil engineer, John Alenyakov, P.E. Mr. Alenyakov testified that the overall site plan that he prepared complies with every dimensional and parking requirement of the zoning ordinance, or that this plan either leaves nonconformities as they are, or in a couple of instances will reduce the nonconformities when the apartment building is constructed. We have put into the book, let me see if I can tell you which exhibit it is. Exhibit 8, behind binder 8, is 2-page exhibit A3. That exhibit lists all of the dimensional criteria in the ordinance and demonstrates that the proposed apartment development satisfies all the criteria. Now, in my view, there can be no dispute that the proposed apartment will comply with all of the objective requirements of the zoning ordinance. I say this because there was no engineering testimony presented by the township to challenge Mr. Olenyakov's testimony, and there were no exhibits presented to challenge the zoning compliance chart on the overall site plan. In fact, Mr. Amuso did not even cross-examine Mr. Olenyakov on the proposed apartment development's compliance with the objective criteria of the ordinance. Rather, Mr. Amuso cross-examined Mr. Olenyakov about what I consider to be irrelevant issues, whether the proposed apartment building would have handbars in the units, the dimensional requirements for elderly housing, assisted living, or how many toilets are in the Shake Shack. So I think that we have satisfied our burden to demonstrate that we comply with the objective criteria. The next one is a requirement that there be public sewer. A very interesting subject. Presented Robert M. Campbell, a PE of Pannoni and Associates, who prepared the sanitary sewer capacity analysis that's an exhibit in the record. Mr. Campbell has over 25 years of experience in designing of new systems, rehabilitation and replacement of existing systems, evaluation of existing infrastructure for capacity determinations, and on with regard to sewers. You accepted Mr. Campbell as an expert in civil engineering with a specialty in sewer engineering. Mr. Campbell testified that he reviewed the township's sewer maps to determine the available options for sewer discharge from the proposed development. He then evaluated the capacity of multiple sewer lines that are downstream from the Plymouth Meeting Mall to determine if there is available capacity in the township's sewer system to accommodate the proposed apartment development. Mr. Campbell testified that in order to determine if there is adequate capacity in one or more downstream lines, at the suggestion of township sewer officials, he reviewed the results of the sewage flow monitoring performed by CSL Services in July and August of 2019 and in August and September of 2020. The purpose of the review was to determine peak flows and potentials for increases in flow during rainstorms, really to take a picture of the health of the sewer lines. The 2019 flow monitoring was performed at manhole 903, which connects to an 8-inch pipe located along Germantown Pike across from the mall, which receives flow from the mall, Narcissa Road Pump Station, Plymouth Meeting Executive Campus, Plymouth Hill Condominiums, and other commercial and residential properties along along Germantown Pike from Walton Road to Lawn Fall Road. Alternatively, the 2020 flow metering was completed further downstream at manhole 968. Manhole 968 connects to a 12-inch main that was upgraded by Preet somewhere around 2007 or 2008. It is located in Arthur's Court, and it receives flow from manhole 903 and a limited volume of residential flow from Lawn Fall and a limited commercial flow from Germantown Pike between Lawn Fall and Middle Lane. After looking at this, pipe. Mr. Campbell evaluated the line in Arthur's Court from manhole 915 through 968 and identified manhole 918, which runs from Lawn Fall Road onto Arthur's Court and then follows a similar path as the other line down to the treatment plant. He looked at this as an alternative sewer connection point for the proposed apartment development, as the investigation showed that there is very little flow in the sewer line from manhole 918 down Lawn Fall into 915 due to the small volume of commercial properties along the line. Moreover, the commercial properties that are in that line, Dunkin' Donuts, Luke Oil, Mattress Firm, are low-use properties with low flow levels coming out of the facility on a regular basis. And then when you get downstream of that, there is a line that has a capacity of 2 million gallons a day and is currently running about less than half full. After gathering all this information, Mr. Campbell testified that he used Manning's equation and used it to calculate the capacity in the sewer line from manhole 918 to manhole 915. He determined that capacity to be 875,000 gallons a day. He also testified that if a limit were placed on the use of the pipe to 75% of its volume during the peak events, the available capacity is 625,000 gallons per day. To support Mr. Campbell's analysis, we introduced the American Society of Civil Engineers manual that states that sanitary sewers should be designed to carry the peak flow from somewhere between 1/2 of the volume of the pipe to the full volume of the pipe. Mr. Campbell then calculated the estimated sewage flows that will be generated by the proposed apartment. He did this by ascertaining the water usage from comparable apartment developments and assuming that the water usage is the best way to estimate sewer generation where the sewage flow is not specifically calculated. Using this accepted methodology, Mr. Campbell determined that the 503 units would discharge somewhere between 35,000 and 65,000 gallons per day into the Plymouth Township sewer system. Based on the calculation of 875,000 gallons of available capacity, or 625,000 gallons of capacity if we're only going to use 3/4 of the pipe, Mr. Campbell testified that there's plenty of capacity available within the Plymouth Township sewer system to accommodate the additional flow from the proposed development. The discharge from the proposed development into the system would be into or downstream of manhole 918, and there are no issues in the Plymouth sewer system from manhole 918 all the way down to the Sussex Square apartments on Plymouth Road. Now, during his consultations with the township engineers, Mr. Campbell was informed that there is a problem with the sanitary sewer line that runs under the railroad crossing behind the Metroplex between manhole 493 and manhole 492, and the township plans to increase the capacity of the sanitary sewer at that railroad crossing. Such increase will cure the problems at the rail crossing. Going one step further, Mr. Campbell estimated that the proposed development with the connection of 503 units would provide the township with funds of approximately $825,000 that could be used by the township sewer system to offset part of its cost of the rail line, or in the worst case, if there was some work that needed to be done between manhole 615 and 618, the developer would pay to the township approximately $825,000. If we stopped at that point, I would say to you that we've conclusively proven that sewer system capacity is available. But the township presented Alan Mason as a witness. Mr. Mason is a professional engineer who leads the township's wastewater engineering consultants. It was Mr. Mason's testimony that sewer systems should be, or sewer lines should be designed so that at the peak flow, not at its normal flow, the sewage accepted should be limited so that the peak flow will only fill 50% of the pipe. That is, even though Preet installed a 12-inch line, it is only allowed to plan to use 6 inches of that pipe in times of maximum sewer usage. So there's a fail-safe there of 50% of the pipe. Therefore, Mr. Mason testified that there is no more capacity available in the sewer for the proposed apartment development. However, Mr. Mason did not prepare or issue any report detailing how or why he came to that conclusion. He conceded that there are sewer lines in Plymouth Township that regularly operate at more than 50% design capacity, and that these sewer lines have not been shut down. When I questioned him about the particulars of the sewer system in the vicinity of the mall, Mr. Mason indicated that he was not prepared to testify to many of the issues at hand, that he had not researched the location of the pump stations in the township that could connect to the lines that service the mall. He had not researched recent developments in the township, and he said that he would need, quote, to pull the map. I suggest to you that Mr. Mason's testimony was not reliable and cannot be relied, was not credible and cannot be relied upon. Going a little further, when I questioned him about the DEP regulations of the sewer system, he admitted that pursuant to the DEP regulations, if the 2-year projections for the township demonstrate that there will not be adequate capacity in a sewer line, the township is required to declare a moratorium on the use of these lines. Mason conceded that not only has the township not declared a moratorium on connections to the sewer lines in question, but that recent developments have been permitted to connect to the sewer lines. Mr. Mason also testified that there is no corrective action plan in effect, which is also a requirement of DEP when the projections for 2 years out say that there will be an overload. Mr. Mason stated that Mr. Campbell overstated the peak flow capacity of the existing 12-inch line that Preet had previously installed to accommodate sewer discharges from the mall property. Mr. Campbell used 75% maximum depth of flow of the sewer line, and Mr. Mason argued that Mr. Campbell should have used 50% maximum of the flow. But Mr. Mason conceded that the American Society of Civil Engineers and Water Control Federation Joint Design of Sewer Systems Manual provides that a sewer designer may set the design capacity of a sewer line at between 50% of the volume of the pipe and 100% of the volume of the pipe for a peak storm. Therefore, this standard allows a sewer designer to project the peak flow using between 1/2 of the height of the pipe and the full volume of the pipe. Campbell took a conservative position and used 75% of the volume of a 12-inch pipe for peak flows. That's clearly within the range. And I just want to make sure that everybody understands this. It's 75%, you can only use 75% of the pipe during the peak flow. Then during regular flow, you're using a much smaller amount. If you've got a 12-inch pipe and you're figuring a peak load, why do you give away and not allow the last 50 or 75% of the pipe to be used? And as I said before, he conceded that the sewer lines in the township flow at greater than 50% of their volume during peak flows, and the township has not declared a moratorium. This testimony that Mr. Campbell should have used the design standard of 50% of the volume of the pipe is simply not credible. With regard to the sewer system south of Plymouth Road and the Sussex Square Apartments, it was Mr. Mason who testified, confirmed what Mr. Campbell had said, that the township is in the process of addressing the existing deficiency in the system near the Norfolk Southern Railroad line, but that it has not declared a moratorium because of that deficiency. It's my feeling that this is more evidence that Mr. Mason's declaration that the design capacity should be 50% of the volume during the peak is a statement that was made up. It was a statement that was made up for the hearing. In conclusion, with regard to the township's position that there is not adequate capacity in the sewer, I would like you to focus on this. We know that Preet installed a 12-inch sewer line somewhere around 2009, 2010, basically to accommodate the flows for the mall. The unrebutted testimony is that the 12-inch line carries very little sewer. We believe that the township's position that Preet installed the line, the Preet installed line cannot carry 65,000 gallons of additional sewage, it simply defies common sense. This is a sophisticated township with sophisticated professionals. It's just impossible to believe that when that line was installed 10 years ago, that it was designed solely to take care of the then existing flows from the mall and Luke Oil and a couple other places. I reread over the weekend my cross-examination of Mr. Mason. It's in 2 pieces, and it's about a half an hour's worth of reading. If you doubt at all what I've said, please take an opportunity to read those cross-examination of Mr. Mason. I think it's a little bit more embarrassing than the way I've characterized it, but I leave it up to you. Bottom line is that I think that by credible evidence, we have demonstrated that there is sewage capacity available. And as we testified at the hearing is Dan Herman, the Senior Vice President of Development, sitting right behind me, testified. If there's really a sewer problem for some area, we'll fix it. We'll fix it. There's no statement by Mr. Mason that there's not treatment capacity. There's treatment capacity. The line underneath the railroad is going to be fixed. We ought to be able to get from Plymouth Road to Germantown Pike. And if not, we'll put in another pipe. So I just don't think that it's credible for the township to try and defend against this application by throwing up this red herring about the sewer. So let me go on to the last aspect. Again, we have the burden. We have a burden to prove, I think we have a burden to prove that safe and efficient ingress and egress, and we're not going to overwhelm the roads. So the hearing presented Joe DeSantis. He's a PE, he's a PTOE, which is some accelerated level of recognition of traffic engineers. He's the president of McMahon Transportation Engineers and Planners. And Joe's the traffic engineer for the proposed apartment building. As we all heard, or as I take that back, you accepted Joe DeSantis as an expert in traffic engineering. Mr. DeSantis has been involved with the redevelopment efforts of the Plymouth Meeting Mall for over 10 years, taking part in the addition of the restaurant uses, as well as the recent repurposing of the Macy's space. He's also involved in the Whole Foods development. Mr. DeSantis testified that he has performed continual traffic studies for the mall as follows. A traffic study in 2005, which he prepared using traffic volumes from, if I said 2005, I'm wrong. He prepared it in 2006 using counts that were made in 2005. In 2013, he conducted a traffic count after Whole Foods was installed, and restaurants were also installed to determine whether there would be capacity for additional expansion of the mall. In 2017, he conducted a traffic study when Macy's closed, and in 2019, he conducted a traffic study after the repurposing of the Macy's. And all these traffic studies were given to the township over the years. Getting into the details, Joe testified that he prepared a transportation impact assessment in connection with Preet's application for the proposed apartment development, wherein he conducted an evaluation of the existing morning, weekday afternoon, Saturday midday peak traffic volumes. He assembled future traffic projections, both with and without the proposed apartment buildings being added to the Plymouth Meeting Mall. In his preparation of the impact statement, Mr. DeSantis used standard traffic study methodologies for calculating levels of service at the studied intersection and trip generation calculations as adopted by the Pennsylvania Department of Transportation, the Institute of Traffic Engineers, and the Federal Highway Administration. The intersections that were analyzed in connection with the study were Germantown Pike in Plymouth, Germantown Pike in Hickory, Hickory Road and the signalized mall access across from Fountain Road, Hickory Road and the Western Mall access, Hickory Road and the Eastern Mall access, and Germantown Pike and Lawnfall Road and the mall access. He also analyzed the Germantown Pike and right-in mall access and the right-in, right-out mall access and the mall access from Germantown Pike and the internal ring road. He analyzed everything. Mr. DeSantis testified that overall intersection levels of service generally remain unchanged when comparing the without development traffic conditions to the projected conditions with the 503 apartments. Mr. DeSantis testified that overall delays on the adjacent off-site intersections and all site intersections with public roads increased less than 9 seconds, with all but one of the intersections increasing less than 4 seconds during all periods analyzed. And this level of additional delay is well below PennDOT's threshold of impact that would require mitigation measures. I've included in the book Joe's chart. It's next to the last item. It shows the levels of service without development and with development. And with the exception of the intersection that we all hate, Germantown Pike and Plymouth Road, all of the intersections are at very acceptable levels of service. Yes, we wait. I go through the intersection just as Ms. Churkin every day. I live in White Marsh. My office is in Bluebell. We get through there. I'm on and off the turnpike all the time. We wait, but not very long, even in the peak hours. Now, Mr. DeSantis testified to something very interesting. Said that while the redevelopment initiatives on the mall over the years have resulted in increased interest in the mall, the total mall site traffic is less today than it was in the mid-2000s, when other uses began to replace the standard retail space in the mall. And a key contributing factor for this reduction in site traffic is the result of the increased diversity and the mix of uses on the mall today, which promotes people coming to the mall for 2 or 3 or 4 things that they used to have to go to 2 or 3 or 4 different places. It minimizes the operations in and out of the mall. Now, just a couple of other facts that Joe testified to. It should be noted that back in about 2010, Crete widened Germantown Pike along the entire mall frontage from 2 lanes in each direction to 3 lanes. We now have 3 lanes in both directions, as well as a left turn lane through the Lawnfall intersection in each direction. And the volumes in and out of the mall have decreased. Any traffic increase from the proposed development would still fall far short of reaching the traffic levels from 2013. In trying to wrap up what Joe testified to, the analysis in the traffic impact study demonstrates that with the proposed apartment buildings, the overall intersection levels of service generally remain unchanged between the without and the with development conditions, and at most an overall delay change at the off-site intersections and the access intersection with public roads is less than 9 seconds. The analysis contained in the study confirms that site-generated traffic can be accommodated at the study area intersections with little change in levels of surface and without any decrease in efficiency. And finally, the analysis contained in the TIA revealed that efficient access to and from the proposed apartment building can be provided safely and efficiently without any undue congestion or interference with normal traffic flows in accordance with the requirements of Section 1101D of the zoning ordinance. Now, Joe testified not only to the off-site traffic, but he testified that he analyzed the internal circulation on the Mall Ring Road in order to determine any improvements that could be necessary or advantageous. Mr. DeSantis prepared a traffic circulation plan to depict the proposed improvements to the internal circulation on the mall, on the Ring Road. I believe that that's the last document in the book. Now, Mr. DeSantis designed improvements on 7 different areas of the mall. And I know that everybody heard it, so I'm just going to brush by it. The most important improvement that he suggested is the improvement to the internal intersection on the mall after you come in off of Germantown Pike. And he determined and he demonstrated with the simulation traffic that what was holding up traffic from getting out was that as cars came into the mall and wanted to go to the north, they made left turns. Those left turns stopped the exiting traffic that was queued up where the Shake Shack is now from making the left turn out. He suggested the elimination and the reconfiguration of parts of that area there. He demonstrated with the simulation how that change would make a demonstrable difference in the queuing at that area. I guess the second most important one to me is the question that Mr. O'Pruly asked a number of times about the safety of making that right turn in at the Lukoil. And you'll remember, and you can see it on this drawing, Joe reconfigured that entrance so that you don't have to have that immediate right turn where you got to grab the wheel and turn it real quick. He softened it. Coming down that road, he separated the traffic that comes together when you're coming from the main entrance and you're heading over toward the Whole Foods from the traffic coming in from Lukoil, so that it's more controlled. He also made a series of changes, and I don't think I have to go into the detail as you come down that road, realigning traffic at the cross where you would go over to the Miller's Ale House, and then he reconfigured the traffic around Whole Foods and where the new building would go, so that there would be smooth ingress and egress from and to the building, and to encourage the use of the Hickory Drive exit for traffic coming from the apartments by making it much easier to come out of the apartments and, instead of heading toward Germantown, go around the back of the theater and come out. And then finally, up on the signalized intersection at Hickory and the mall, and Hickory and the exit way from across the street, where the buses come in and the buses get stuck, he would redesign that and give a left turn arrow to get the traffic to be able to clear out sooner. I think we all spent a lot of time looking or watching what Joe said. I don't think I have to explain that anymore. I have one last piece. That's the testimony of Mr. Graham. Mr. Graham was the township's traffic engineer. James Graham was accepted as a traffic expert by you. His testimony concerning the traffic impact of the proposed apartment developments was demonstratively unreliable, was not credible, and I don't think that you can rely on it in making a judgment. There are a myriad of items where Mr. Graham didn't seem to be talking about the same property that we were talking about. But most importantly, Mr. Graham failed to perform any scientific analysis to support his assumption or his conclusion that the proposed apartment development will cause traffic congestion, back up at the Whole Foods. Mr. Graham testified that the proposed development would cause a 2-second increase in the delay on Lawnfall Germantown intersection, and that this minor 2-second delay would create a significant negative impact such that you should reject this application. That's just mind-blowing that he would say that. He didn't use proper scientific methods to estimate the proposed apartment's effect on the traffic. That is, he did not follow the accepted methodology and take actual traffic counts at relevant intersections. Rather, we all heard him, he took the 2005 McMahon traffic study, or the 2005 counts that were in the 2006 traffic study, and increased the traffic each year by like 1.5%. When I cross-examined him, that essentially meant that there was an increase in the traffic from 2005 to now of 35%. He did not do counts. He admitted that this was an unusual methodology. The McMahon study showed that the wrong methodology was used and that Mr. Graham greatly overstated the current traffic. The foregoing is even more incredible to me because there have been the 4 additional studies that I spoke about before given to the township, and somehow he insisted on using a 2005 study. We all know that the township approved Macy's, it approved Whole Foods, it approved the restaurants, and each time there was a traffic study. When I asked him why he used this unusual methodology, he admitted that the failure to conduct proper scientific analysis was due to, quote, the essence of time. He also accounted for the failure to take any traffic counts at all on the interest of time. He created an exhibit only showing 2 through lanes on Germantown Pike and was surprised as could be when I told him that there were 3 lanes. He conceded that it would make a big difference if Germantown Pike were 3 lanes instead of 2. I'm not quite sure exactly what he did, but he presented a photo of what looked like a similar simulation as Mr. DeSantis used. But when we got into it, it was clear that he had manipulated that photograph to misrepresent the correct simulation. When he was called on his manipulation, he then called it, quote, a snapshot of time. All I can say is whatever he did demonstrates that his testimony was not credible, and he didn't use proper scientific methodology. And then when he came back for the second time, he admitted that his own conclusions showed minimal increased delay from 2 seconds to 7 seconds. But he told us that the 2-second delay in making the left turn in from eastbound Germantown Pike into the mall was a significant negative impact, and that you should turn down this application because of it. Mr. Graham confirmed that PennDOT does not require improvements until there is an increase in more than 10 seconds, and no improvements would be required by PennDOT because of the development of the building. Somehow his own testimony demonstrated that the additional queue lengths created by this development would be minimal, from a half a car length to 2 additional car lengths. But he kept going, and he kept saying that this was a bad development. I do not think that I have to say anything more about Mr. Graham. So I'd like to wrap this up, and I really appreciate your patience. I know I've taken a lot of time, but we put an awful lot of testimony on. I haven't mentioned Dan Herman's testimony, the last hearing. Peter said it's all irrelevant, and maybe from a technical point of view, it's not on point, but I think it is relevant because one of the things that we've got to demonstrate is that what we're doing is in the public interest. And you heard Dan testify about the history of the malls, and we all know that the Montgomery Mall was sold at sheriff's sale a month or so ago. We know how many other malls are in trouble, and Preet's trying to save this mall. And I appreciate all the ladies who got up here and who are frustrated with the traffic, and I appreciate them saying, I don't know what it is, but there ought to be something different to save the mall. This man's got one hell of a lot of experience. You heard him. Preet, we're trying to save the mall. The comprehensive plan says we should save the mall. The comprehensive plan says put elderly housing, assisted living on the mall. Well, that's what they tried to do in the big building. And it says put apartments. We want to put apartments. We're not touching a piece of green space. We're not taking what little green ground exists in this area. We're taking macadam that's been paved over for whatever it is, 50 or 60 years. I hope that you will be convinced of our right to this special exception because of that long, somewhat boring rendition of 7 cases that I told you about. I am as convinced as I can be that if this ends up to the Commonwealth Court, the Commonwealth Court will find that this is a use of the same general character. That just may be too long. So please, number one, because it's right, we have the right, as I've said, and number two, because the community needs it. We do not need a Montgomery Mall situation here where I'm getting calls from potential developers all over. Can we put in e-commerce? Can we put in 2,000 apartments? That's what we're seeing. So please apply the laws I've said and grant us this special exception. And thank you for 9 nights of incredible patience and putting up with me and Peter fighting like cats and dogs. We really love each other, but that's what we do. Thank you very much.
Thank you.
Thanks.
Thank you.
I'd like to take a 5-minute break to get some air.
Get some air.
I got a question for you.
Oh, that's the thing.
I don't think so. No, not. I don't think so. Well, what, for elderly? I don't think that's
Step outside from that.
That's my office, right? I think that is what was proposed. Yes. But they withdrew. Huh? They withdrew it. The assistant. So there's a limit because there's a parking requirement. So you can only put in so many parking spaces before you go over the impervious coverage or stuff like that. Stormwater. I believe so, yeah. Yep.
It's like the same job.
Right.
There's nothing in the ordinance that limits on the of motel and.
No, it just says road. Like it's basically the same as like a restaurant. So how many tables can a restaurant have? How many seats can a restaurant have? That's exactly. Yeah. So like whatever it is, 1.7 parking spaces per unit. So that's your limit right there. So, right. I would not. As Dave said, I would not get into it.
I'm just thinking.
No. I think personally you have to go with, like you said last night, it boils down to, is it the same general character? You know what I mean?
Well, it's not. But I mean, I was going to add on size.
I know what you're saying.
That's another fact.
But if you go what you need to do to improve the special exception, I think I pointed you guys to that section of the zoning ordinance. variance, right? It doesn't say size and scope.
No.
Well, yeah, but that's not in the.
Right, but I'm trying to just
I know what you're trying to do.
square the circle.
I know. Yeah.
No, more, I already, see, one of the things, if it doesn't satisfy that, the traffic service as well.
Yeah, right. No, I know what you're saying. Yeah.
If you trim out the first wire, the
Right.
second wire.
It does, exactly, right. So,
So it's like, I feel bad for these people. It's too bad. I talk to the guys that will go with you there.
right, exactly.
That's actually,
There's so much time and money in this.
somebody else would like it.
Right, right. No, I got you.
No one's at the Phillies game.
Who is?
No one.
What's the score, brother?
They're still in it.
Have they scored yet?
Nothing.
1-0.
They still got a shot.
Baltimore.
They still haven't scored a run
They can't
against
score a run
Baltimore.
after the worst
Scored a
of
run
the
against Baltimore.
It's brutal. It's not even in the realm of reality.
Thank God I'm a Dodger fan.
You're all over the place. I have no respect for your sports at all. All over the place. Dodgers.
It counteracts me being a Jet fan.
Oh, so he suspended the
Give you
Nets.
some level of success.
Really ready.
I doubt it. I just don't understand how he's saying he's not taking green space.
Pretty good. I think so. There are my questions on that.
Do we have a
I
cutoff
feel like
time?
there's some green space in there that, I feel like some of that is green space. Don't you think so? Currently? I mean, this isn't where the old IKEA building is, it's over here. Like, this is way bigger than the existing footprint of the IKEA building.
Alright, so I'm not that bad.
It's pretty clear that the uses don't have anywhere the number of.
Like behind there, it's adjacent to the movie.
He said they were
I mean, so here's Whole Foods.
these guys are gonna have to come to the table and negotiate. I'm just pissed that they have the opportunity to clean up that ring road now. Why don't they just-
That's Whole Foods. And the high road, and here's the mall.
I don't know what company built that.
And if that's Whole Foods, I mean, this is the old IKEA building. They want to build it on this whole space. Not just where the old IKEA building is, all of it, taking over all of that.
Is it a special exception or is it a use variance?
They're asking for
I guess it's not,
I want to see the definition.
but it's not developed currently. I mean, who knows what that even is? That's dirt. This is like PennDOT storage, I think.
Special exception pursuant to 1100R.
That's the ordinance.
Right, okay.
I want to know what the definition, where's the definition?
How about Brian? Usually knows this stuff. Where is special
It's a use
exception?
permitted,
Not defined
it
anywhere.
has a permitted use that must meet two criteria.
Not sure,
One,
I'm not sure.
that it's permitted as a conditional, as a special exception by the zoning. ordinance. And two, that it meets all of the objective criteria of the zoning ordinance. That's what a special
Oh, these quotes?
It's a permitted use. It's got to be, but it's not permitted by.
Yeah, here, it's, Dom, it's on, it's here.
200 something?
It's on page, it's actually in the
But
appendix.
you've got to show that it's not going
Section
to
12,
be
page 21.
adverse to
Dom.
public health, safety.
I think it's 21 on this. I was just looking at
They don't
the glossary.
argue, they don't,
It's just 21 on.
which is
Yeah.
show that it's permitted.
I do, I had it marked
It's not.
section myself.
It's already listed as a
Have the
special.
following powers for
Only
special exceptions to authorize an application. Special exceptions.
it's the same general character as one of those two units.
I've gone online.
That's it.
It's their reference. I know. I've been going online and trying to find it.
We get moving? All right, we're going to resume the zoning board hearing. Thank you.
Thank you, Mr. Chairman. Thank you, Mr. Kaplan. Mr. Amuso.
Thank you, Mr. Sander. And thank you, members of the board. I certainly echo Mr. Kaplan's comments. The township is grateful for the amount of time you've put into this hearing, certainly many nights over Zoom, and it's nice to see a lot of you in person tonight. Look, I'm gonna pick up where Mr. Kaplan left off about what is the right thing to do here. And look, the township, we represent the township, and the township is vehemently opposed to this application. And I can sum up our position in two words: Arthur's Court. If you approve this application, you will destroy the homes on Arthur's Court. You heard the testimony of the township engineer. If this project is approved, there will be backflow of sewage into the basements of the homes on Arthur's Court. The manholes on Arthur Court will burst with sewage. There's only 20,000 gallons of capacity left and 503 apartments. 503 apartments will make the capacity go over by 95,000 gallons. 95,000 gallons of sewage that the system cannot handle around Arthur's Court. And that's not the right thing to do to the people who live on Arthur's Court. They're part of this township as well. They're residents of this township as well. And they've put their livelihoods, their lifetimes into making their home at this township. And if you approve this application, their investments are gone. Their homes will be destroyed. But it's not just the right thing to do, and I'm a lawyer, so it's hard to talk about the morally right thing to do. So I'll get back into more comfortable territory of what's the legally right thing to do. And it also happens that it's the legally correct thing to do to reject this application. The PRETA has made this application, the framework is a special exception. The township doesn't believe it qualifies as a special exception, and we'll get to that. But let's say it does. Let's say it is of the same general character of the elderly housing. I'm surprised that PRETA keeps bringing up the idea of the motel motor court. Their expert clearly disagreed with that position, so there's no evidence before you that this is of the same general character as a motel or motor court. But let's concede for a moment that it's the same general character as elderly housing, assisted living housing. So a special exception, as the old joke goes, is neither special nor an exception. There's a set of rules that have to be met. And if they're met, you need to grant the application. But if they're not met, you cannot grant the application. This is not a variance. There's been no request for a variance. All the economic issues have no relevance here. Of course, we're admitted over the objection of the township. This is a special exception. And so we take a look at the township zoning code. And if you look at section 2101D3, it lays out the rules that you have to consider when you look at a special exception. And PRETA simply doesn't meet at least three of those requirements. The first of which is that it cannot unduly burden sewer. This project will unduly burden the sewer system of Plymouth Township. And we're not talking about the railroad. This is above the rail. So even if we put a 20-inch pipe under the railroad, it's still going to destroy the homes on Plymouth Court. You heard our township engineer, Mr. Mason, who has many, many years of experience, and as Mr. Kaplan conceded, is very sophisticated. He told you what the capacity of our sewer system was. And he also pointed out to you that their expert made a fundamental mathematical error. Do you remember? Their expert is off by 1 million gallons per day of the capacity of the sewer system. 1 million gallons per day. Their expert said it was 2.6 million gallons per day. And Mr. Mason said, no, it's 1.6 million gallons per day. And they've never disputed that. They've never come back and said, no, this is why it is 2.6 million. They've never responded to our pointing out that they made a fundamental mathematical error on the capacity of the sewage system. And so putting 95,000 gallons more a day than our system can handle, that is the very definition of unduly burdening the sewer system. So on that factor alone, even if this is a special exception, they have not met their burden there. In fact, if anything, the evidence has shown that they will unduly burden the sewer system here in Plymouth Township, and again, for those poor residents of Arthur's Court. The other requirements that they have failed to meet are that the project will not substantially increase the traffic congestion in the streets, that's subsection A, and that they'll endanger the safety of persons by the improper location or design of facilities of ingress or egress. We certainly had an issue with the traffic report in this case. We couldn't get it, right? For months and months and months, we didn't have the data behind their traffic report. And finally, I think on the third or fourth night of hearing, we got the data. And what did the data show? Traffic's going to get worse, right? This has nothing to do with Mr. Graham. This has nothing to do with what Mr. Graham was forced to do because he didn't have any information from the applicant. Once he got it from the applicant, the traffic gets worse. Their own numbers show that the delays at the intersections go up. They want to say, what's a few extra seconds? What's a few extra car lengths? That makes the traffic worse. Not better, worse. And we all know what the traffic is like already. And lastly, they have not properly or safely placed places of ingress and egress. As you know, they refuse to make the residents of the apartment building use the Hickory exit from the mall. They are forcing everybody out the Lawn Fall exit, which is the worst exit. And so they are not allowing the safety of persons for ingress and egress. So on those 3 grounds alone, any one of which independently is sufficient to deny this special exception, they have not met their burden of proof. So as a special exception, this application fails. But it's not a special exception. It's not a special exception. As Mr. Kaplan correctly points out, you are not the legislative body, and I know you know that, so I'm not telling you anything you don't know. It's council. And what was the unrebutted testimony? Council specifically removed the high-rise apartment building from the shopping center district. There was a time where our zoning code here allowed just what is being proposed tonight, allowed a high-rise apartment building. But that was specifically removed by council in 1980. And the applicant has made a big deal about the comprehensive planning vision. And that's a nice document, but has no force of law. Again, and I know you know this, you are not the legislative body. All you can do is apply the zoning code as written. And Township Council, who is the legislative body, specifically removed a high-rise apartment building, and they've read the planning documents. They know what the county thinks the vision is, at least for the township, and they have not made a change to the zoning code. They have not put back in the high-rise apartment building to the zoning code. And just think of the logic of that the legislative body specifically said, okay, you're permitted to build this right now, we're going to remove this. It's no longer a permitted use. Does anyone think they meant, well, we meant that go ahead and build it, but just with looser restrictions? No. So this is very different than all of the cases they cited where you had specific history of removing that specific use from the zoning location. And it's not of the same general character. You heard substantial testimony. This is a much, much more intensive use. Mr. Kaplan talked a lot about, well, there's no moratorium, and we haven't done this for sewer. Right, because we didn't have any plans for 503 apartments to be built in the shopping center district. That's not part of our plans. That's not part of the zoning code. So there's no reason to do anything with the sewer capacity up to this point. The sewer, it has some capacity. It has enough capacity to build 150 units of the elderly living, but it doesn't have enough for 503 apartments, which, as the testimony showed, is a much more intensive use than elderly living. The elderly living, they had communal dining. Obviously, it's fewer people in each apartment. It's just a much less intensive use. The legislative history here is clear. The township removed the apartment building from the shopping center district. You have no authority to put it back in, and the planning document is not law. And there's been substantial evidence that this project, if it were to go in, would absolutely unduly burden the sewer system. It would absolutely increase the traffic. And so for the right thing to do and the legally correct thing to do, remember Arthur's Court. It's a legally correct thing to do to protect them. The applicant has not met its burden, and it will unduly burden the sewer system, increase traffic, and it's not a safe way to ingress and egress out. But more importantly, it's just not permitted in this zoning district. It was specifically removed by council. And if anyone's going to put it back, it has to be council. Thank you for your attention. For those many reasons, you need to reject this application. Thank you.
Thank you. Thank you, Mr. Musso. Is Mr. Gunlock here?
Yeah.
Mr. Gunlock, would you like to make oral argument?
No, thank you.
Okay, you're a counsel of record. I wanted to offer.
Thank you.
Okay. That concludes oral argument. Does the board wish to deliberate?
Yes, I do.
Okay, we'll go off the record and the board will deliberate.
Vesper or something? So it's fun. So I did it. Here's why. So my mom was actually the coxswain for St. Joe's. Oh, cool. He rode for the track freshman. It's such an intense yeah. Yeah, so my mom was the coxswain for St. Joe's. And so, like, I was interested in Upper Murray, and they have a boathouse. And it's a program where Parks and Rec, summer between 7th and 8th and 9th grade, I wrote for like it was like an 8-week program. In the summer, you went like once or twice a week, you know, water, learned how to build in, all the other stuff. Was thoroughly enjoying it. Got to high school, went to the South Epic rowing program. I thought, this is try it. Great exercise, great socially. Anyway, so intense. Just like yourself said, you have to choose between rowing and doing the shows. That was the end of crew for me. You were gonna pull me off the stage, so. You're not gonna go back to there's always that where you so much difference from, I mean, 20 years ago when I was driving. It's so much different. I'm not going down there and sitting down on the car. I just have to keep the car going. Kid from Bluefield down there, I was going to the out.
A little one, so she'd rather be in school than not. You were embarrassed and we were all laughing.
Oh, wow.
We'd all been there.
Yes, so what we're doing is, our house is built in 1910. Oh. Last time?
Notwithstanding the trees, I was right.
You're all scout. Right. So, yeah, they're going to build
She's got all the things. So this one, do this one. So, when he comes up with a conclusion, okay, we'll set some down or whatever. We're gonna come back 2 days a week.
You know, it's funny, actually, the partner, even though I still look at it,
It is.
I noticed the Bryn Mawr, and I couldn't remember if it was there before or not, or something. Super harsh. Yeah, that's great.
First time she looked at it, just it was like earlier. Lots of reasons. Let me tell you, like a smart group of people. People want to be with other people to fight. And I said, chat this or something. They're talking all day. It's not the women, it's the women, it's the men, it's the.
I was about to ask if she was like, you know, particularly, she's got any good. I assume you would, you're Bryn Mawr, you're interested. I'm meeting with Eddie Foster, Tom, Thursday.
we're going to resume the zoning board hearing.
Thank you, Mr. Chairman. Let the record reflect that the zoning hearing board deliberated and are now back on the record. Is there a motion?
Mr. Solicitor, I would like to make a motion that we deny the special exception requested as follows to allow 503-unit apartment building according to section 1100.R.
Is there a second?
I'll second it.
There's been a motion and a second. We'll take a roll call vote. Ms. Leddick? Are you in favor of the motion to deny?
Yes, in favor.
Ms. Pygat?
In favor.
Mr. Daly?
In favor.
Mr. Aprile?
In favor.
And Mr. Ramondo?
In favor.
5-0 to support the motion to deny. The hearing is now closed, and we will issue a written decision supporting the decision of the board within 45 days of today's date. Serve it on the parties, and we want to thank the parties again for their patience and their hard work in presenting a case that was challenging and not easy for the board to make a decision. So with that, we are closed. Thank you.